Okay, good evening, everyone. My name is Babasi Michelle. I'll be your anchor for today. Just a quick announcement. The program is being recorded and streamed live on our social media platforms, Facebook, YouTube, other social media platforms. So this program is a quarterly intellectual property program for law students, young lawyers, and intellectual property enthusiasts across Africa. Mentees are afforded the opportunity to access valuable intellectual property advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced IP mentors. This program seeks to encourage continuous intellectual property training, development, and evolution in Nigeria, Africa, and around the world. You can watch our videos by searching Jiipcc on YouTube and on Facebook. We have other resources available there. The objectives of the program to provide easy access to intellectual property guidance, training, and resource materials for students, young lawyers, and IP enthusiasts in Africa, to facilitate dialogue and network among experienced and less experienced intellectual property practitioners and stakeholders, to transform mentees into intellectual property mentors and leaders for the next generation of mentees, and to facilitate further intellectual property mentorship, internship, scholarship, and IP-related job placements for the mentees. Today, we have three guests. We're going to have three guests with us. Our first guest mentor is Oluwadamilola Sofowore. I'm so sorry if I Sofowora. Yes, Miss Oluwadamilola. And Miss Oluwadamilola she works as a legal officer with KC Gaming Networks. She has years of experience in legal drafting, filing, expatriate matters, legal research, and agency matter. She's going to be taking us on gaming law today. Good evening, Miss Oluwadamilola.
Good evening.
Can you hear us? Okay, she
can. I can hear
you. Okay. Thank you so much for joining us.
Thank you for having me too. Okay. Good evening, everyone.
Good evening.
Sorry. So, yeah, my name is Oluwadamilola Sofowore, and I'll be talking on governing laws, gaming laws in Nigeria. So I have my slide there, which I will share with us after. Oh, I don't know if I can share it now.
Yes, you can.
Okay.
Yes, you can.
Okay. One minute, please. Okay. Okay, so I just did. Okay. Well, the first thing on our content is what is gaming law. Please, can you all hear me?
Yes, we can hear you.
Okay. So what is gaming law? And gaming law is regulated by gaming is regulated by the National Lottery Commission, the National Lottery Commission's law, and then the Lagos states is actually regulated by different laws. The criminal code law, then is actually regulated by different laws, but the most relevant ones that we usually make references to is the National Lottery Regulatory Law and then the Lagos State's lottery laws. National Lottery Regulatory Law of 2005 and Lagos State Regulatory Law of 2004 as amended. The increased participation in the online sport betting market can be attributed to technology advancements. We all know the impact of technology, in our daily lives and in everything that we do. So gaming has gone past the traditional way of placing bets. Maybe you go to shops and everything. You can place bet online if you want to, and you can request for your winnings when you have. So the increased participation in the online sport betting market can be attributed to technology advancement, globalization, affordable access to internet and on internet-enabled devices, online payment platforms facilitated by fintech companies. Then gaming has also provided employment for a whole lot of youths, in Nigeria, even abroad. So gaming is evolving in Nigeria. When gaming started in Nigeria, it was not well known, and the notion people had about betting or gambling, so to say, is like a non-conventional stuff. Like, oh, if you bet, there's it's like against the law. But with the way gaming is evolving now, people tend to see the future in gaming. People tend to see the future in gaming, and it has, posed a lot of employment for thousands of Nigerian youths and expatriates, like I said. So we'll now be looking at our regulatory regime of gaming law. Like I earlier said, gaming law is regulated by the Criminal Code, the National Lottery Act of 2005, and the Lagos State Lottery Law of Lagos State Lottery Law of Lagos State, 2004 as amended. I don't want to go deep into the law, just to state the laws that regulate gaming in Nigeria. So the most relevant law, like I earlier mentioned, the National Lottery Act 2005, which bettered the National Lottery Commission. Sorry, the National Lottery Regulatory Commission. Then the Lagos State Lottery Law of Lagos State 2004 as amended, which bettered the Lagos State Lotteries Board. Lagos State Lotteries Board, and they are the ones in charge of licensing, regulating the activities of the gaming industry. Now, moving on to issues relating to gaming law. There are several issues relating to gaming law in Nigeria as we speak. And the first issue, in no particular order, I want to speak on the issues in no particular order. I will be talking on underage gaming, which is a very big issue. It's a very big issue in the gaming industry, because underage gaming is something that the law frowns at. Is a very, very grievous offense to see an underage in a betting shop or placing bets or doing anything. And what do we mean by underage? Underage is a person or a minor under the age of 18. The legal age for a person to place a bet, because we're talking about gaming, is 18 years and above. So anyone under the age of 18 years is categorized as an underage person. So underage gaming is frowned at, like it is against the law. You know, we had an issue with underage gaming sometime last year. Our regulators, they randomly go to some of our agent shops, and I think they went to a shop in Ibadan, and they said they saw a boy in a betting shop, and we were shocked because we have the sticker that we give to our agents: no underage gaming. Anyone below the age of 18 cannot be allowed to place bets, and everybody's aware of this regulation. So, they just sent us a message that, oh, they found a boy in the shop and what have you, and we were like, oh no. In the course of our investigation, we were made to realize that the boy was actually sent to pick up a phone from the shop. It was caught in the process of going to the shop to pick up a phone. So that's to tell you the extent at which they frown at minors going into a betting shop. So another issue.
Sorry, please, can we hear her, or is it just me?
No, we can't hear her. I think she's having network issues.
Nah.
Okay, she's back.
Okay, we can hear you now.
Oh, okay.
We
Well,
can.
then you could. Oh, wow. Apologies for that. I'm sure it's the network.
No problem.
Okay, so I was talking about alternative dispute resolution. So I said it is usually advised that there should be an alternative dispute resolution rather than taking every matters to the court, because the gaming industry is so what's it called? It is termed as unconventional by the courts, and there are no precedents, so to say. Not that we don't have cases in court, but there are no precedents to follow when it comes to gaming. So it's usually advised that the operator come together with the customer, we call them punters, to agree on a particular dispute, via dispute resolution. And then the first point of contact is to go to the regulators, which I mentioned earlier, the National Lottery Commission or the Lagos State Lottery Board. Those are our regulators. The first point of contact is to report any issues to the regulators. When you report to the regulators, they reach out to us to find out what the issue is so that we can settle it amicably. So another issue is taxation issues. There is a misconception that gaming companies don't pay tax. We don't pay taxes. It is a misconception. We pay we pay a lot of taxes. There are some things I cannot disclose, but we pay. They believe we have our books. We have auditors coming to audit year in, year out. We pay taxes. Gaming companies pay taxes, but there's a misconception that gaming companies don't pay taxes. It is a misconception. I can't begin to go deep into it, but there is a misconception in case you are hearing that, oh, they don't pay taxes, oh, they run with people's winnings and everything. Is not true. It's just a misconception that they have, because the gaming industry is new to Nigeria. So it's, trying to gain grounds and everything. So we have just about few operators doing so well in the gaming industry. All right. So another one I want to talk about is data privacy and protection and anti-money laundering, which is very important. Please permit me to okay. So under the data privacy and protection regulation 2019, it specifically addresses data privacy and protection in Nigeria, and it said by saying that, okay, the statutes that regulate data privacy and protection in Nigeria is Nigeria Data Protection Regulation, NDPR in 2019, which specifically addresses data privacy and protection in Nigeria. So basically, data privacy, you cannot obtain someone's information without their consent. Basically, that's data protection is talking about consent. For us as an operator, for filing of anti-money laundering, I'm sure I don't know if you know about anti-money laundering with a body under the EFCC that monitors anti-money laundering activities in Nigeria. They require us to get certain informations from our customers. And those informations are private to them. Private information like their name, their phone numbers, their addresses, their ID card, and their stakes, their winnings. All these information are private to them. But we have to file these returns to the anti-money laundering just to monitor the gaming activities in our company there. But under Data Protection Act, data protection is saying that this information have to be given with consent of the customer. The customer can also come to say, I want you to delete the information that you collected from me. You have to delete it. And anti-money laundering is saying that we should get this information, and you're supposed to keep this information for 5 years. So how do we balance this out? We need to also respect the data protection regulation, and we need to also respect the fact that we need to keep information of our customers for 5 years. So we need to speak with our regulators. We need to come to a common ground, because we cannot infringe on somebody's protection, data protection and privacy. Cannot infringe on their privacy. So that data protection is a very, very big issue in the gaming industry that needs to be taken note of. Also, multiple regulators. We have, like I said, gaming has a lot of regulators here and there. We have like different states will come and say, oh, these are their own regulations and we need to follow. Federal will come and say, this is their regulation, we need to follow. But the regulators that we know that is, standard for the gaming industry is the National Lottery Commissions Act, and then the Lagos State Lotteries Board, which regulates licensing gaming activities in Lagos State for the Lagos State Lotteries Board. Then for the National Lottery Commissions, Regulations Commissions, they regulate for national. Okay, so those other states like what's it called? The northern states, the eastern states, they're supposed to come under National Lottery Regulation Commission. But we now have all these states coming up with their own regulations to follow. This is multiple regulators for the gaming industry. And it means paying double taxation, which is another issue, another issue to gaming law. Paying a lot of taxes here and there because there's nobody regulating the gaming industry. But recently we have a body, what's it called? I can't recall now, but we have a body that brings all operators together under one umbrella to tackle these issues affecting of operators in Nigeria. I can't recall the name of the body now. I'm so sorry for that. So I hope I've covered everything.
Thank you so much.
Okay. Is my time up?
Yes, your time is up.
Oh, okay.
Thank you so much.
Yeah, you're welcome.
Before we move on to our next mentor, I would like to just acknowledge the presence of Mr. Max and Mr. Folari, mentors as well. Our second mentor is going to be taking us on film law, Zerona Duke Phillips. She's an alumna of the University of Pennsylvania Carey School of Law and the New York Film Academy with certificates in filming and producing. She is a New York bar and Nigerian bar certified attorney, possessing varied experience in intellectual property law, art, media and entertainment law, and project finance. She has advised on diverse transactions for multi-million-dollar infrastructure projects and transcontinental financial acquisitions to music licensing, film and theater productions, trademark and copyright protection and enforcement. Thank you so much for joining us.
Sorry, thank you for having me. I forgot that I was muted for a moment. So let me, may I share my screen as well?
Yes, please.
Okay, let me see if I can figure out how to do that. Bear with me. Okay, can you all see my screen?
Yes, we can.
Okay, wonderful. So let's see. So I'm going to try really quickly. I think we have like 10 to 15 minutes thereabouts to put into a nutshell film law, and specifically what I'm going to concentrate on is the production agreements that you may come across, or you likely will come across in putting a film together. These are very important, some obviously more important than others, but none should really be neglected at all. So we're going to look into, so we're going to look into film production transactions. Essentially, Nollywood back in the day, I don't know if you remember, Nollywood would just churn out all these films constantly. No one really cared about production quality. Okay, let me not make a generalization, but production quality was not the highest focus or concentration. And obviously things were being done very informally. This goes for across the entertainment industry as a whole. And certainly the film industry was not, was a part of this. But, in recent times, there've been new technologies that have been brought into play when it comes to film, whether it's distribution, whether it's the actual making of the films and all of that. And Nollywood, because we're Nigerian, because we do not carry last, we are here, and so we made the necessary changes. So you may or may not know, but Nollywood is actually the world's second largest film producing industry. We're second only in terms of producing, like the volume of films that come out of this country or come out in the world. We're second only to India. And after us is Hollywood. So it's Bollywood, Nollywood, and then Hollywood. Of course, when it comes to how much money actually is coming out of films, we're third, which is still not bad at all. Like I said, traditionally Nollywood films were informally produced, but with the upswing in digital exploitation, producers have been compelled to formalize their film productions. And when I say formalize their film productions, I mean that they have been compelled to make sure that these necessary agreements are in place in order to satisfy their distributors and financiers, because now they're working with international companies, they're working with international film production companies, actors, actresses, distribution, sources of distribution, etc. And these entities are going to require, not request, require that these formalities are followed. So first thing that we all have to remember is that show business, of which the film industry is a part of, is a business. Okay, and businesses are run primarily on contracts. I think first year of law, contracts is one of the first things that you are taught, and it never goes away, right? Every single aspect of the law, in some way or form, you're going to have to deal with contracts, and film law is not exempt from this. So the reason behind this is so that people are clear on their objectives, they're clear on their obligations, and they're clear on the consequences for what would happen if they don't adhere to all of these things. But ultimately, the goal is to ensure a successful relationship and a successful project. When it comes to film, these contracts all together, and it's a huge volume, like a solid stack of documents, right? And these contracts all come together and they're referred to as the chain of title. And so essentially I have a definition there, a list of agreements that indicate that you own or have licensed all the rights to the film. Essentially, if you can properly say that you have chain of title in your film, you're telling that investor, distributor, whoever it is, that don't worry, if you get involved in this film production, no one is going to come after you for violating their rights because I have secured everything, right? So moving on, a film can be split into 3 key sections. You have pre-production, production, and post-production. And each of these sections have their own agreements that you'll have to pay attention to. So first, pre-production. These can also be called development agreements. And these should take place in the period before shooting begins. They involve finalizing all the rights, whether if you're making a movie based on a book or a movie based on someone's life, you need to finalize all those rights. You have to secure the script, secure the rights to the script. And at this point in time, you may also be trying to secure some financing. Let me take that may out. You will be trying to secure some financing because already you'll have bills to pay. You will be trying to pay your writers. You'll be trying to pay the people who you're optioning the rights from or purchasing the rights from. I'll talk a bit more about that in just a moment. And very soon you're going to be, paying your actors, and you need to have some money in the bank in order to make that happen. So I mentioned rights purchase or options agreements. These are what are used to secure the story, the underlying story, right? I'm going to go a little bit out. There's a recent movie. Somebody remind me, if anyone can say it, I would be so happy right now. It's an Ebony Life film, right? About a journalist who went undercover as a prostitute. Am I ringing any bells for anyone? Hey, well done. Okay, so I don't know if you're aware, if you're following, the business, But, there was a big stink about that because the journalist, it was based on her life. Well, that's what she claimed. And I'm not judged. I'm not here to say, it's all alleged. We're lawyers here, right? So she said that it was based on her life and that Moa Budu and Ebony Life Films did not properly secure those rights. Now, they're going back and forth. Again, we're not here to make a determination about that. But I just wanted to bring that as an example to show why it's so important that from the onset, you have secured that, have all your documentation. It would have been wonderful if they would have been able to say, here, this is the agreement that you signed. It clearly states what rights we're securing, for how long we're securing it, what you're being paid in consideration for us taking these rights, et cetera, et cetera. You knock that out. So when you're trying to secure rights, you can either do a rights purchase, which is an outright purchase of the story, or the story essentially, or the script. Maybe a script has already been written and you want to purchase that. Essentially, they've given it to you. No one's coming back. You've bought it, right? That's what a purchase is. They may be able to depend. I mean, everything comes down to bargaining power when it comes to negotiation, and when it comes down to negotiation. But the owner of the rights may or may not be able to hold on to certain rights, or they may have to give everything off. But that all depends on it. But essentially, a rights purchase agreement is, I am purchasing it outright. I do not owe you any more money after this. And you cannot come back to me and say that you want it back. It's mine now, right? On the other hand, you have an options agreement. And an options agreement essentially gives the producer an exclusive right for a period of time to purchase the screenplay. So say I'm a producer, I don't have the $250,000 that you're requesting right now, but will you take my 75,000, or let's say 50,000 for easier math. Say, will you take my $50,000 right now and hold it and give me this option and give me 4 years to put all that I need to put together, put it all in place so that we can produce this film. And if at that time, at the expiration of the term, I'm not able to do what this option, says that I'm to do, then the rights will revert to you. So that's essentially what it is. Right. Another big one in pre-production is the writer agreement. You may need this where the producer has an idea and needs a screenwriter to convert it into a viable screenplay, or if maybe you need a writer to rewrite an existing screenplay. But one key thing that must be made clear in such agreements, when you're hiring someone to do something for the film, you need to make sure that the agreement states that it's a work for hire, or in Nigeria that it's the word just went out of my mind. It's a C word, but basically that you're hiring someone to do it's commissioned. Thank you. That it's been commissioned. It's very, very important. That language must be in the agreement. This agreement is going to form part of your chain of title. And if that language is not in there, you may have an issue. If the writer comes back and they have a savvy lawyer, you will be in trouble. All right. Now, another one that you may have at the pre-production stage is collaboration or co-production agreements. This is where you might be working with other producers to put this together. Make sure that your association is clearly spelled out. There's no point in getting into bed with someone when you're not sure exactly what you're getting out of it and how you're getting it. So yeah, essentially, that's what that is. How am I doing for time, by the way?
You actually have 2 minutes.
Oh my goodness. All right, let me figure out what is important. Film financing, very, very important. You can see my screen, right? So you have debt, equity, and pre-sale financing. Really quickly, debt, borrowing money. You may require repayment before the film is commercially viable. And you may have high interest rates. Debt is not advisable. If you can avoid it, it would be wonderful, especially in Nigeria, especially in our economic climate. Equity, you're selling ownership interests in the film. Of course, that means that when you're getting your money back, you're not getting the whole thing, after when profits start coming in. And the pre-sale financing is when before the film is made, you can approach Film House, Netflix, all of those people and say, hey, I have this fantastic movie that I'm working on. How about you give me some money and I will give you, exclusive distribution rights. And, distribution is a really key thing, but we would need more time, definitely more than 2 minutes. Investor agreements, essentially make sure you have one. This is where, in fact, I wish I should have paid more attention to this. I was talking about the other stuff, but the financing in film is so important. You really need to make sure that everything is clearly spelled out. Let people know when and how they're getting their money. Profits will be shared, what credit they're going to get in the film. And sorry, so just before you cut me off, I'm just going to, instead of going in detail, I'm just going to go really quickly through all the other agreements, but I'm not going to go into detail, don't worry. So I'll skip the pre-sale agreements because you can see them there, distribution agreements, etc. But then we were going to production agreements, which is the period where you're actually making the film, right? So here you have it split into 2 sections: above the line crew and below the line crew. Above the line are the director, producer, cinematographer. You have to make sure that they have their agreements. Below the line are the people who handle the hands-on stuff, so the gaffers, lighting, people, all of that. These contracts are a lot more straightforward, really simple, but again, just make sure that it's all in there. Whether or not their job is technical or creative, you do need to make sure that you secure those rights. So for the director, cinematographer, they're creating what may be a copyright. And so you definitely want to make sure that you own that copyright. And then the cast obviously will have their agreements at this point in time. You'll need location agreements, licensing agreements, and then, did I skip something? Yes, sorry. Licensing agreements are going to be in post-production, actually. And so these would be, say you secured some financing through product placement, all right? Or even if you didn't secure the financing through product placement, maybe you have a scene where the person is drinking Coca-Cola. You need to make sure that you contact Coca-Cola and get their permission to have their logo on your film, because they need to sign off essentially on being associated with your film. Music is a huge thing. It can cost you most of your production budget, to be honest. But if you don't have it, it can also completely destroy your production. It's one of the really key things that are important in chain of title. You absolutely must have your music licenses through synchronization agreements. And it's really important that you have someone, you must understand how the music industry works. You must understand how the film industry works. So, for those of us who are lawyers, for those of us who are practitioners of film production, just, make sure that you know your stuff, make sure that you're getting the right people to represent you, whichever the case may be. So to wrap up, we have chain of title. Everything I've spoken about is all chain of title. It's that the body of contracts that protect the producer, essentially, and say that he has all the rights to this film. Next thing is granting or retention of rights. What have you given out? What are you keeping? And finally, profit sharing. It's a business, all right? We're all in this to make money. So make sure that it's spelled out from the beginning, who, how, what, everyone is getting paid and when. So that's me in a nutshell. I'm sorry, I ran a little over. Thank you very much for listening.
Thank you so much. And our final mentor for today is Miss Odwak. She's a passionate and experienced attorney at Fashion A&T Law who helps creatives, leaders, and entrepreneurs significantly increase their bottom lines, all while reducing and avoiding risks. She has litigated a wide variety of issues in California courts and represented and counseled a range of clients in matters ranging from contract disputes, copyright and trademark infringement claims, licensing to all types of diverse music, fashion, and film industry agreements. She also brings a unique background to the problem-solving legal issues for her clients. She's an ex-fashion model and has over 2 decades of hands-on fashion and entertainment industry experience, which runs deep and diverse, encompassing the disciplines of media, publishing, journalism, fashion, modeling, music, branding, public relations, sponsorships, fundraising, and digital marketing. She's also a recognized thought leader and trailblazer for her work on Africa's emerging global fashion and entertainment markets and the niche practice of fashion law in the United States. And in fact, she has authored a combined total of over 11,000 articles, some of which have been syndicated globally. She's also an adjunct professor who teaches social media law and ethics and social media data analytics at the Academy of Arts University in San Francisco. In 2019, she crafted, inaugurated, and taught the first ever fashion law course at California State University, Sacramento. For her work in the field of law, fashion, entertainment, and media, she has earned numerous awards, recognitions, including an award from the American University Washington College of Law for her legal impact in the field of intellectual property in Africa. She has also been a legal commentator and an invited speaker to numerous organizations, including the Fashion Law Institute, Wharton School of Business, and others. Thank you for joining us, Ms. Udwa.
Thank you for having me. Thank you so much. This is my second time here, and it's always a pleasure to be able to give back. So here's where I want to take the conversation in light of all the amazing presentations by my colleagues on gaming and film law. I was asked to speak on fashion and music. So what I want to do, since we are all lawyers or potential lawyers, is to really, really bring it home on the practical application of it. So let's start with fashion. Let's say Ugo Monyu walks into your office, and so far so good. Let's assume he's not this big designer just yet. So he walks into your office and then he says specifically to you, attorney, I'm interested in retaining your services. I've just built this fashion brand. It's gaining a lot of momentum. And whenever I dress anyone, whether celebrity or not, everyone's asking me for my designs. And then he tells you, I've created a very interesting real design that is Japanese inspired. And I think I'm going to dress Ebuka, the personality, because he has a wedding coming up and it's the Benki W wedding with Adesua. It's a big wedding. And I really think that with his visibility and with the uniqueness of my design, that I want to go ahead and just register the work. So how would you advise that client? And specifically looking at it from the business side, the IP side, and the licensing side. So that's sort of what I'm going to be playing with to cover a lot of the concepts that have been talked about today. So let's start first with the business side. We're not going to delve too much because this conversation here seems to be more focused on the intellectual property side. So suffice it to say, you want to make sure once the client signs the dotted line and obviously pays you your fees, because you got to get paid as a lawyer running your business. So once they do that and you now have a relationship, attorney-client relationship, one of the first things you want to ensure, if they don't already have that infrastructure in place, is make sure that the business formation side is intact. So that business formation side spills into what Zerona was talking about. If your film business spills into what the other speaker was talking about on the gaming side, right? So you want to make sure they are incorporated as a business. That would be all under company law in Nigeria. In the US, that's corporations law or business law, as we call it here. They have their LLC in place, limited liability company, that shields them from liability. And then, or they can be a corporation that also helps shield them from liability. If they don't have that money, assuming Ugomonye doesn't have the money or the capital, which a lot of clients, particularly on that startup stage, designers, particularly African designers, including Nigerians, might not have that money, Nigerian designers. One of the things you want to consider is, okay, well, you might not initially have that money, but if you're getting into a partnership with someone else, let's get insurance maybe to protect certain things for the business. So certain general liability insurance for patrons that will be coming in and out of the store. So we've filled out that block, and it's just a quick summation of the things you should be looking for. Is the business set up infrastructure-wise well? And that's also important for investments, right? So Zorana was talking on the film side about a film business and the importance of film financing. If you are a film business or a fashion business, necessarily you also have to think long-term about investments coming into the business. So infrastructure, incorporating the business becomes important down the line. But if you don't have the funding, you can start off first as a solo practitioner, but get insurance to protect certain liabilities. So we've done that. The next phase is Ugomonye tells you about this real design. How are you going to advise him, right? And Japanese inspired. Ebuka is going to, Uchendu is going to be wearing it. It's going to be a big deal. It's like a interesting modern take on the Agbada that we all know. And it's all for, the young, aspiring, Afropolitan, cosmopolitan Nigerian men that would wear it, and also looking to have it be worn beyond the shores of Nigeria. So one of the first things you want to consider is looking at Ugomonye's business, look at specifically what's the name of the business, right? And are there any kind of logos that were designed as part of that? Zoruna just talked about if Coca-Cola is if you have in your film, Coca-Cola, a person drinking Coca-Cola, you want to trademark clearance of that in the film. So that's what we're talking about. Coca-Cola has its own design and logo specifically that distinguishes it from one brand, let's say Sprite, versus another brand, which is the Coca-Cola itself. So a trademark is a source identifier that distinguishes a good or service from one good or service distinguished from another. So specific to Ugomonye, you're going to tell him, well, you need to register your trademark. It's important for purposes of your business, because in the fashion industry, unlike maybe music and unlike film, your name is everything. And if you can build that brand equity, which simply means you're building a lot of credibility, momentum, everybody's knowing you, they want that brand, they want that one that Ugomonye design. If you can build that brand equity, then what ends up happening is you're able to then take it and license it within the continent of Africa and outside of. When you think about all the major labels some of you like to wear, whether it's Gucci, Fendi, all that, a lot of those brands are licensing globally because they can't come into Nigeria necessarily and maybe have the manufacturing infrastructure and maybe the supply chain to get the product directly to Nigeria is too much of a headache, and taxes and all that. So if someone in Nigeria says, I want to sell Gucci, they can buy that license, they can broker that deal. And to do that, really, they're getting the logo, the trademark specifically that has been built on the brand equity. So that's why you want your client, Ugomonye, in that instance, to register his trademark, among other things. So we're still keeping it very domestic on the Nigerian end. We haven't gone international yet. We'll deal with that in a minute. Now, assume he says, well, okay, attorney, awesome. I'm going to get my business formation documents together and you're going to help me do that. I'm going to get my trademarks together and you're going to help me do that as well. What about, I've heard this thing called copyright. What's that all about? And do I need to copyright my designs? So how do you advise him? You say, yes, copyright is super important. Since you have created this very interesting design, it can also qualify as for registration under copyright law or the Copyright Act in Nigeria. Also on the US end as well, and across so many other countries through the Berne Convention treaty. And the way you advise on that copyright registration is you say, okay, Ugo Monye, for purposes of your Agbada itself, even though you're taking a modern spin on it, it's still more so functional, right? Agbada is a cultural outfit we all wear across Nigeria, and you're most likely with the Nigerian Copyright Commission are not most likely going to be able to register the Agbada as a silhouette of its own, because the copyright laws that we have existing will not protect that particular silhouette that you've created. Because to do so is to give you a monopoly over everybody else, and we all got to wear Agbada. You don't have a monopoly over it. Instead, what we can do is register that design. And so what does that mean? When we register the design, it's going to give you what's called an exclusive right? A monopoly that you own this bundle of rights. And those bundle of rights will allow you to be able to either license it, which we're talking about in trademark, or assign it, sell it right out. So what are those bundle of rights? You have a right to reproduce the work. You have a right, the design that you have registered, you have a right to reproduce it. You have a right to display the work. You have a right to create a derivative work. So take the existing work and create something else out of it. Think of music sampling, for example. You have a right to perform the work. You have a right to distribute the work, among other things. So based on those rights, you have your trademark registered and you have your copyright registered. If someone should infringe on that work, then that gives you the power to be able to say, hey, the work is registered, you needed my consent to use it in the first place. And since you didn't have my consent, two things can happen. Cease and desist, stop doing it right away, and pay me all of that money and proceeds you've already made. Or if you don't do that, then I will have no other choice but to take legal action against you, which would be litigation. So on the copyright side, as you're advising the client, obviously the designs they're creating, and that sort of goes on the trademark side, but the designs they're creating on the copyright side is not going to be only confined to Nigeria. And the reason is because we live in a global society. There's the internet, things get on the internet, and all kinds of copying can happen. So assuming he says, well, there is a movie called Coming to America 2, and by Eddie Murphy. 30 years ago, it was a classic. This time around, it's been, a sequel has come out. And even Davido, a performing artist and well-known global recording artist, was also a part of it. And I noticed that the costumer, the person responsible for creating all the wardrobe in the film for purposes of what everybody would wear, essentially took the design I've already, created and, basically had local tailors copy the exact same design and then used it in the film with no attribution, no compensation, no consent in any shape or form. So can I file a lawsuit in the US for infringement? Well, if we go back to the fact that the work is registered in Nigeria, right? You had your client, you advised him, he properly registered the work is now registered in Nigeria. He can then, without having to file a registration here, because in the US, if you're a US citizen, you need to file a registration with the US Copyright Office in order for you to file a legal action against Eddie Murphy or whoever the production companies are in this instance. So he tells you that, and you say, okay, well, you don't really need to do much. We can contact a local US California-based attorney or wherever jurisdiction we choose to for purposes of the film, and they can file legal action without you having to even register the work here. And why is that? Goes back to that Berne Convention. So the Nigeria, the US, and many other countries, several hundred other countries have relationships through what's a reciprocal agreement, right? Essentially, if you respect the copyright of my citizens, I will respect the copyright of your citizens. And as a result, the work that Ugo Monye created, specifically his design, is recognized here in this jurisdiction on the copyright side. And then vice versa, if I create work here it's recognized over on the Nigeria side, even if I'm not a citizen of Nigeria. And so if someone in Nigeria infringes on my copyright, I can get local counsel there and take it from there as well on that legal action. So you've now advised your client on that as well. Now let's get to patents. Patents deals with essentially inventions. So if there is anything about that design that has to do with actual invention, or usually you're dealing more on the computer side, technological invention side of things, then you want to also ensure that that client registers his work. On the patent utility side and patent design side is typically how that's split into it. For him, it would be going the patent design route. Then he tells you, well, within the company that I've built, I'm worried about a particular trade secret that I've created, trade secret that really helps my business really stand apart. Is there a particular way to protect it through copyright or intellectual property law? And your response is, well, that's not necessarily IP law per se, even though it's sort of categorized under it. So your trade secret really will be under your contract law, and you, the business owner, are responsible for keeping it a secret within the business. And so you advise him accordingly that whatever it is that he has to make sure that it's confidential, maybe have his employees or potential employees sign a non-disclosure agreement and ensure the processes and who has access to it is limited, because once it becomes exposed, it's no longer a trade secret. So what else is left to advise this particular client on? Because when you're talking fashion, it's such a big spectrum in terms of the value chain. But we've picked this one particular client on the design side because over and over again, when the public thinks about fashion, including the attorneys who want to delve into that realm, they often usually think more on fashion designers, even though there's so many other players in the space. So we did not, let's go back a little bit. Let's say that the designer also tells you that they have dealings with a manufacturer in China, and that's where they get most of their production, their fabric designs, because they deal with that manufacturer who does all the fabric production work. So you want to ensure that that particular client of yours gets into manufacturing production agreements. That way you can sort of outline everything. Obviously there are issues when you start dealing with an international country, like China particularly. It tells you his frustration in Nigeria. There were over 70 textile mills. Now most of them are closed. Production is so hard. Making a garment in Nigeria is far more expensive than overseas. And that's why he's having to outsource that. But you want to, once he tells you that, what you want to ensure is that you have that production agreement in place, that you look at the jurisdiction of where it can be enforced. You don't want him going to China for that to be enforced because he doesn't speak Chinese, and most likely China courts will not be favorable to him. So you want to see territorially if that can be more enforced in Nigerian courts where they speak English, and sort of outline that. And he may not have much leverage or bargaining power with that. It might just be a situation where, you know what, you either buy the fabric from the local markets, Aswani market, or any of the local markets there, or it is what it is, and you just deal with it. So having said that, if he says, well, I've also created a very interesting fabric design, that also goes on the copyright protection. You want to make sure that you register that on his behalf. So what's really left? Two key areas on the fashion side for this particular client that is a fashion designer. And then I'll just wrap it up with just the overall overview of things you should be thinking about on that fashion value chain. So let's say fashion licensing, right? Big one, I already talked about it. For the most part, once you build that brand equity, you're going to be licensing the brand, right? So Marc Jacobs, Gucci, we haven't really seen on the Nigerian end our brands really able to get to that level. We've been able to have some high-end, high fashion brands, but haven't been quite successful on the licensing part. Hopefully we get there as our designers continue to think more on the business of fashion. Hopefully we can get there because we have some great designers, but on the licensing side, we're still we've got work to do. So assuming though that Ugomonye builds that brand equity and is now able to license it. Your role as an attorney would be to broker those licensing deals in a way that makes sense for the client, and in a way where the client can still has a little bit of oversight. It depends on the deal. You can have non-exclusive licenses, so that allows him to license it to several other people, not just one person exclusively, or you can have exclusive licenses with carved out exceptions of certain oversights he might or might not have. You can have an assignment of rights if he wants to sell that completely out, but probability is it's going to be licensing within the context of fashion. And there's so many things he can do with that license, right? So he can license it for purposes of just apparel. He can license it for other merchandise, from shoes to bags to everything else. I mean, sunglasses, everything. You can parse it out on that copyright and the ability to reproduce, and also, on the trademark side, the ability to parse it out and have so many other different lines within the fashion brand that is the licensee coming to him, the licensor. And then the final thing is he's worried about counterfeiting. And he says, well, they're knockoffs of my clothing in a lot of the, bend down select places. I go and I see literally knockoffs of my clothing. And so can I sue? Can I go after these people? You say, well, the realities of the Niger market is I don't see return on investment. If you're going after those particular persons, it might not be worth the dollar for you to go after those knockoffs, particularly because the knockoffs don't have your logo on it. They're just exact copies without your logo. That's what makes them a knockoff. But on the counterfeiting side, he says there are lots of counterfeiting goods in the Alaba market, in Balogun, all of those places. And it's just becoming ridiculous. I'm seeing everyone wearing my purported design, which is not mine, but with my logo on it. I want to do something about this. You say, okay, we can employ we can employ law enforcement. Without the other stuff that they do. We don't want the other shenanigans. We want them to keep it nice and clean on the law enforcement. Good luck in Nigeria, but it's possible. But basically, we want to be able to confiscate those goods and get law enforcement and border patrol as well involved in that. And so counterfeiting is that not only that you're knocking off that exact copy, but you're now putting the logo on it, and you advise them and you say, well, why don't you show me and teach me as the attorney how your goods really look, and the quality, the texture, really understanding it, because these days the counterfeiters replicate it to the point where it looks so real. So once he educates you about the product, then what ends up happening is, regardless where you see it, you're able to know as well. You work in line with the client, and you work in line with law enforcement as well for purposes of counterfeit goods. There are other ways you could try to solve that, but that comes more on the business side for the client to think through what he wants to do with his products, maybe if there are excesses and things of that nature. Now, having said that, there's so many other areas like the retailing aspect, where the merchandise is sent to one of the stores in ShopRite, for example, in order to retail and sell it. We don't really have that kind of really built out mall systems, although we're starting to have malls across Nigeria, but it's not per se accessible to the average person. So the average person is still not going to go to the big malls to necessarily shop per se. So when we start getting into retail agreements that are part of this discussion, and what are called chargebacks, so products that don't sell on the floor, the retailer sort of chargebacks to the designer, and they end up losing a lot of money in that process. We don't really get into that kind of discussion on the Nigerian end. So I'll put a pin in it and just stop right there on the fashion side. Let's go to the music side. Let's say you now have an emerging artist. It could be Ugomonye's brother, or it could be somebody else you know from high school that has always been great, and you guys used to just bop it and have fun in your secondary school or primary school. You always knew he had the it factor, and he knew you had the it factor. You were going to be that lawyer come what may, lawyer for life. That's you. So now you're a lawyer, and now he's like, his music is just taking off. So he comes to you and say, hey, we always had this dream we would be, you know, where we were supposed to be, and now we are. And I want you to be my lawyer, no question about it. So I have some tracks out already. The tracks are doing really good. I even got Beat 99.9 FM to play my music without having to do no payola. That's how good it is, because the street is demanding it. So the radio, disc jockeys, etc., have no choice but to play it to stay relevant. So what's the first thing I need to be doing now? What should I do? I'm confused. I don't know where to go. People are calling me, etc. So your process is still going to be similar to what you do with the fashion business owner or the film business owner. That formation part I talked about, you want to get that formation together. And then on the IP side, you want to say, well, you're already trying to sell and make money off your music. Do you have the work registered? So now we zoom into just copyright law for purposes of music. We don't really get into the other areas per se. They're all very relevant, but for this purposes in this discussion, we just zoom in on copyright law because it's super relevant on the music side. So you tell him, okay, great. You already have your music out. Are you making money off it? He tells you, yes, you know, a few people here and there, but really, ultimately, you know, we're in Niger market now. It's just the real is the real. So the real money I'm making is through live entertainment income. And you explain to him the reason why you're making money through live entertainment income is in the music market, there are three pocket areas of how you make money in the business. The first side is the music composition. So you tell the client, oh, I see you're writing your music, your lyrics, you know, you're creating the lyrics to the songs you're singing and performing. So those lyrics, that's your composition, and you make money through an avenue called music publishing, essentially. But the industry is not as robust. Post-COVID, we're now thinking about music publishing in the Nigerian space and trying to enforce those rights and trying to get those agreements in place and trying to ensure our performance rights organizations like COSON or now MCSN as well joined is actually able to help us with this processes, trying to make sure we have music publishers setting up, etc. But overall, historically, that's not been our strongest suit. And then he tells you, well, you know, I also have, you know, the recording, I've placed it no longer on CDs, but I'm putting it on USBs, MP3s still for downloads. It's also streaming on Spotify as well. You say, okay, great. Historically, the way we were making money in the business was through the Alaba markets and the marketers or traders who were selling. We would go, the artist, the talent, or the label would go to the markets and sell that particular music. And the marketers would think they own the entire copyright, but they did it. And they would cut out the artists, but pay them a lump sum. Well, now you don't necessarily have to worry about that with the recorded aspect of the music. You have the ability to make monies off the digital distribution of all of the different players in the space, including the digital retailers, among others. Or you could go through the third parties, like Free Me Digital. I think they have a whole system set up that can help you with the placement of your songs in all the major retailers like Spotify, Apple, etc. And then the last part of it is the live entertainment income. So you tell him, so what you're doing now, the money you're making from the shows now, that's your live entertainment income. As you grow more brand equity and people are hearing about you, just like the Davidos, the Wizkid, and everybody else that's gone before you, you're going to get an opportunity for endorsement deals, sponsorship deals. Recently, there was an announcement that Davido is going to be a part of a movie here in the US that's already shooting. And we already know he was a part of a movie for the Coming to America 2, where he performed. So you're going to get such opportunities as well, book deals, movies, etc. All of that falls into the category of live entertainment. However, I already told you, you tell your client, I already told you, yeah, live entertainment is cool, but COVID, we saw that, you know what, Amor, you have to really, really hustle and put everything in place, because if you don't, this life, Sha. So you tell them specifically, you tell this client specifically, live entertainment is not going to cut it for you anymore. Recorded music is not really rolling. The record labels in Nigeria are barely able to keep afloat. You know, I mean, there's a whole discussion on the non-existence of record labels. So it's not really going to work. You need to really, really be thinking about music publishing. So he tells you, well, what do I do? So you tell him, well, first of all, you want to make sure, since you don't have a music publisher, there are few music publishers in Nigeria now, but since you don't have one, there are options. You are automatically a music publisher. So you have to set up your own music publishing company. You could do that, or you could go through independent agencies, although they might be abroad, but they seem like they might be able to collect music publishing for you. So you can go through those companies, you tell him, you'll sit with them and vet and determine which companies are the best ones for him based on all the facts he shares with you. In the meantime, you tell him also, since he's an independent music publisher, he needs to register his work with the performance rights organization. He can choose whether MCSN or COSON, and tell him that unlike the US market and other markets, but particularly the US, COSON acts as both a mechanical license organization and also performance rights organization. Of course, it's going to say, what does all that mean? But in the meantime, you say, the first thing I want you to do, every time you ask him, any of the songs, do you have any collabo? He says no. You say, oh, great, awesome, I'm so happy. So guess what? If you do have collabos and you get in the studio with someone else, make sure you have what's called a split sheet. And with that, you're going to specifically indicate what percentage of the songs you own. Okay, so you want to make sure you say, for example, I own 50% of the song, the other person owns 50%. You always want to make sure you do that, because if you don't, it can be a whole mess. You also possibly want to, if you don't go beyond the bounds of the split sheet, or if you do go beyond the bounds of the split sheet, you want to get an agreement in place, maybe as joint collaborators on music, and just cover a lot more. But the split sheet would be at least at the basic level to give you all the necessary details that's necessary to turn that over to the performance rights organization. And the performance rights organization, the reason they exist is because you cannot individually go all over Nigeria or all over the world when your song is played, publicly performed. So radio, TV, etc., restaurants, hotels, airplanes, you can't go and collect all this money. In fact, one of the major issues now is a lot of our artists are having uncollected royalties. They've been paid, but it's just sitting there because no one knows who it's supposed to go to or whatever. So you don't want that kind of situation. Meta tags are a major issue, not IDing your music, not knowing or filling all the key things out so that your performance rights organization can collect. So the reason you go to a performance rights organization is they have the infrastructure and the people to help you collect globally. So that's why you go to them. And what they're going to do is they're going to issue a blanket license to all of those people I talked about that are music users. And those people are then going to essentially ensure that when your music is played, the performance rights organizations, when your music is played, then you get that money back. And that ties back to that copyright of that right to perform, reproduce your work, perform, display, distribute it. And then the final thing, just to cover it on that side, and then I'll probably just wrap up with a few more points on as part of advising this music client. The final thing on that publishing side would probably be two things: the mechanical license. So you say, well, again, you're writing your composition. So if a label comes at you and says, hey, I want to have one of my artists on the label perform your song, record and perform your song. Every time that they record and perform that song, right, you get mechanical royalties on it, because that song is going to go under the CD, it's going to go as vinyl, it's going to go as MP3, etc. So you get mechanical royalties, you get payment for that on the composition side, because you're not signed to this label. If he asks you, what about, I've heard Ms. Zerona Phillips is talking about film and all this projects. And I know she has a client that I've been eyeing. I really, really want to get my music there. And I think that my music will work for the upcoming film that they have coming up, right? Or maybe not necessarily her client, but he says, I heard that Kemi Adetiba has King of Boys 2 coming up. And it's actually also, she's got a deal with Netflix on it. And not only that, there's also something in the works. Well, I want to be in line for the next something in the works. How do I get my music placed? You tell him about sync licensing deals, something that Verona was already alluding to. So you want to ensure that in that instance, it's negotiated directly with the producer. So it could be negotiated with Kemi Adetiba directly, or whoever the third party is. Or if that company has, so the producer or filmmaker, indie filmmaker in this instance, has the infrastructure, then they might hire music supervisors that you can then talk to as a third party to place that music. And if it's not Kemi Adetiba, Imemi Songs, all the different people out there that your client could potentially have music placed. Sync licenses are now huge in the States and outside of, in bringing revenue in for a lot of music clients. The final area I'll cover, and then we can always get into the Q&A, is, so you've got your client through music publishing, et cetera. You've got the formation side of the business, entering the business, establishing, dealing with all the IP issues. And now he's like, well, what if I gain a lot of traction? Because as it stands, I've not even done much, but I've had Chocolate City, and I've had a couple of other labels, PD Picasso's label, forgetting his name now, or Mr. Easy. They're all contacting me, even Starboy, and they want to sign me with a record deal. So what do I look for? Should I sign it, or should I just stay solo on my own? You tell him, well, it's interesting. Those are really big names. The key thing is to see what exactly they can do for you, what value. It tells you, even David Joseph was just hollering at me on Twitter and Instagram. He's like, just say it now, just sign you to DMV Records. So you say, okay, well, the key thing is to see what they're offering and what they can do differently than what you already have going on. And if they can show you real value, then sure, why not do that? Otherwise, there's so many things to look at in a record deal. But one thing you have to understand is the record deal here in Nigeria is different from that in the States. So excuse me 1 second. So we're going to have to ensure that the deal making side of things with the record deal, I'm just making sure this is fully charged. The deal making side of things with the record deal is where where it makes sense for you. On the Nigerian end, on like the US end, where the deals are brokered, you could have a 70-30 split on royalties that come in, or you could have a 60-40 split. But these days, even on the US end, because if the artist is coming with a lot of traction, they can play a lot more with the less than 10 to 11% or maximum 12% you would get on the royalties end. As the recording artist. And of course, you're going to tell him about advance payments and advance fees and how that works, and the term and relationships and the structure of a record label, among other things, and advise him accordingly. So I will put a pin in it, stop there. And if you have any questions, I'm happy to answer. But that would be just the overview, taking the fashion client through that value chain, and then taking the music business or music recording artist or writer, songwriter and recording artist through the music value chain. So thank you for having me. Any questions, happy to answer.
Thank you so much, Ms. Udwa. So please, let's have questions for all three mentors. You can unmute yourself to ask, or you can write it down in the chat and I'll read it out.
Oh, I missed your time is up. Sorry. Sorry about that. I was wondering when you would tell me, but I wasn't looking at the thing. I was looking at the camera.
Thank you very much, Serona. Thank you, Ms. Udwa. Thank you, Oluwadamilola. Thank you so much for sharing. Really appreciate it. And so I'd like to say that if anyone has a question, please just unmute yourself and ask a question. If it's not possible for you to do that right now, we have some other mentors in the house that might have something to add. So if you have a question, just unmute yourself and ask, or type it in the chat box. We have Mr. Folarin here, Mr. Max, and Mr. Ayokunle Adetula. They are mentors that have been with us since the first quarter, they always attend, and at the end, they try to contribute to what has been discussed already. Mr. Marx is saying that it feels like he deserves a diploma after listening to the three speakers. Agree. Because it's so loaded. So I think, Mr. Folari, if you have anything to say, please, you can just come online and just add to what has been said. Then after him, Mr. Max, Mr. Ayokuni Adetula. If you have a question, please feel free to put in the chat box or just unmute yourself and ask.
Juliana, to Marx's point, you might want to consider in the US here, it's possible, given how long you do this mentorship and the quality of people you invite and their legal practitioners, it is possible to look into what we call MCLEs here, but I don't think that's a requirement on the Nigerian side, but you can make this MCLE certification course where you get a diploma certification, if you will, of some sorts. But I don't know if that's available in your jurisdiction, but that's an option.
Okay, thank you very much. Mr. Polari, please, are you here? Okay, he's not here.
I'm here, Juliana. Excuse me. I was struggling with my what's it called? My okay. Fantastic presentations. I don't think we'll drop this. I don't think there's anything to add, or subtract from. I think all the presentations were very, very well put together. It's actually a mystery as to how we're able to cover such a large surface area in such a short time. Especially people who ended up talking about fashion and music, and covering the field in such a very short, such a wide area in such a short time. Fantastic stuff. I would agree. It would be a good idea to. Mark said it's not strictly enforced. Well, there are options. I think there's an MBA, there's an Institute of Continuing Legal Education. So, Juliana, it is something to look at or to look into. And top-notch stuff, very good. I've followed, I think, almost everybody. I followed Ms. Uduak for a couple of years. And it's always a pleasure to listen to her speak and to read her. So fantastic stuff. Well done, Juliana. Thank you very much for having me. I've learned quite a lot here. Zerona's presentation, KC Gaming. I keep forgetting her name. Oluwadam Lola. I did a case against them a few years ago. But there was something she said. She said something like, they're not making money. That's contrary to everything that I've heard all my life since I was born. So I don't agree with that.
I didn't say
They're making a lot of money.
Okay,
no,
I didn't mention. I didn't say
they are making a killing. But well done. Fantastic presentation. Thank you very much. Yes.
Thank you, Mr. Polari. Mr. Max, do you have anything to add also?
Yeah, thank you, Juliana. It will be a tough, just like Mr. Folani has said, nothing could be added to what we have heard so far, but I must commend the three ladies who listened to this this afternoon. This has been excellent and fantastic. I must give the highest kudos to all of them. For me, it's coming at it particularly, like I always would say on this program and encourage the mentees, when you hear people speaking with such deep insights from the industry perspective, it's a great privilege. Of course, Mr. Foran Aluko is here, and people think I pull his legs when I say he was one of the people who led me into IP, but it's just the truth. I was all through when I was in school, I never really learned about IP law, so I knew nothing about IP law. In fact, my first ever encounter with IP law was because I was reviewing an agreement for a client, and I saw some part about, the assignment and licensing of IP rights. That was actually my first ever encounter when I was maybe 2 years plus as a lawyer. So my journey in IP has been a painful journey of learning myself. Look back 10 years from now, it wasn't very easy to come across IP knowledge because, we didn't have the online revolution as much as we have today. So it took a long time for me to really come across people with such sound practical knowledge, and of course to build myself from learning and then working with clients and, continue learning. So I just encourage the mentees, take these opportunities as really a golden opportunity for you to really get on the fast track of an IP practice. And I just want to end by supporting Oluwadamilola when she said, I think what she said that Mr. Aluko mentioned was when she said, people think the gaming people don't pay a lot of tax. They actually pay a lot of tax. I remember just lately, I was working for a client, and I remember when we sent them the first rough estimate of what their cost implications would be like to even start up the gaming business. The license fees alone, and my people almost, in fact, that Zoom meeting, thank God it was a Zoom meeting. I believe we had the meeting in the building, somebody had jumped out of a window. They couldn't believe their eyes when they saw the cost implication and then saw even the taxes, because some of the taxes in that industry is even on gross, not even on your net profit, on gross collection. So it's brutal, but then of course it's a very lucrative industry as well. So
very.
But it's a good, it's a good place. I encourage them, the mentees, speak an interest in that kind of industry. It's growing in Nigeria. It's an industry that is only set to keep going up. So when we talk about buying the dip, if you get into the gaming industry now, you are really buying the dip, and I assure you that you are only headed upwards. So the gaming industry is headed to the moon, like Dogecoin. So thank you all. Thank you, and thanks again, Zerona and Udwak. It was fantastic.
Okay, thank you, sir. Mr. Ayokunle Odetula, please, would you also like to add something while we still wait for the mentees to ask questions?
Well, I don't think I have so much to. I don't think I really have anything to add, but to thank the speakers. It was an interesting discussion. Max captured it when he said he will have awarded himself a diploma. I guess I would have done that too. The talks were quite clear and concise, and as the discussion was going on, I had a reason to chat up one of the mentors, and I was saying, this is what is going on today. It's like it just came and compressed the thing together, and then we should have actually sort of separated this thing so that as we take in those things, you allow it to settle down. So I want to also say I'm grateful. Sometimes mentors learn too, and that's the beauty of this whole thing. There are things I picked here and there, and I know I have a lot to go and read. When I heard about the number of articles that Ms. Udwak had published, I know that I need to actually read. And for me, I'm very expressive. I would be reaching out after this session because I'm on leave and I actually need to read. That said, I'm actually meant to be on another webinar for 6, so I would actually like to take my leave at this point. Thank you so much.
Thank you for coming.
Over to you, Michelle, please. Okay, it's like Michelle's internet has logged her out. We're supposed to have group presentations just from 3 groups, group 3, group 4, and group 2. So I don't know if they're ready for their presentations. Group 3, group 4, and group 2.
Group 4 is here, ma'am.
Okay, please go ahead.
Okay, let me share. We're treating film law. That's our own presentation. I want to share my screen. I'm sorry, I'm coming. Okay, let me just start.
Yes, I think that's what it's thinking.
Let me just start. So our person that spoke on film already said a lot, like everything in the presentation we were prepared has been said. So let me just run through it again. Film law is quite a big deal anyway, both in Nigeria and outside, because a lot of us love movies and it's part of the entertainment industry. It's a big part of it. So under film law, they have intellectual property film rights, which are protected by copyright, trademark, and patent. And without these important rights, the artists and the actors and writers, generally all creatives that are under the entertainment industry, under the filming industry, will not be able to make their profits, and all their hard work will go to waste and not be recognized. So although filmmaking is quite complex and it entails a lot of people, but the intellectual property always refers to the unique products and the ideas that have been created by the artists or the actors or the writers or the producers. And under the umbrella of IP, you have to find the concept of copyright, privacy rights, publicity right, and trademark. We already know that intellectual property plays a very vital role in making film, and in every stage of film making process, intellectual property rights is very key and very, very important. So the important protection in IP for film law is when a person authors an original work in a tangible form, it has to be copyrighted. And you have to copyright the work you make as an author, so that another person will not take the work and take the credit for it, and so that the author can also gain profit from the work. But many people make the mistake that it's difficult to obtain a copyright. It is not actually difficult to obtain a copyright as a lot of people think. It's very simple. You just have to write it down, film it, record it. You have to have the copyright idea, and then you have to register it. And then these rights, you can make copies of it and distribute your work. You can perform it in public, you can display it, you can sell the work, you can transfer the work. So the exclusive right when you register your copyright work is to you, is for you. So not just does copyright protect original work as film, as not just does it protect the work as a filmmaker, but like other people in the film industry, it helps to protect their work. And during the process of making movies, producers always negotiate for agreements during IP rights. So a producer could make an agreement with the writer of the script on the profit to be made and where they can use the work, because the writer is the owner of the script. This type of agreements take place between the producer and the lawyer involved and the owner of the work. You can trademark a word, a design, a symbol, a phrase to be used in film. There are some phrases that you see in film that could be owned by a particular person that came up with the word and already registered the phrase or symbol as their own. And then you see it in a movie, you know that definitely they would have gotten permission of the owner of that work. So there's always there's always a need to copyright whatever work you have in the film industry, so that your work does not just go without recognition. Film won't exist without patent technology, and movie making industry involves a lot of technical equipment such as cameras and equipment for editing and lighting and special effects. And innovation is a hallmark of filmmaking, and patent plays a very, very huge role in helping with copyright and trademark. And so in the film industry, we cannot overemphasize the need to copyright every single thing, whether as a scriptwriter, as a producer, as a director, whatever idea you're bringing into the filmmaking industry, you should always have it at the back of your mind, at the front of your mind, with your lawyer, to always make sure that you register it and you copyright it. So thank you very much. That's our group presentation.
Thank you very much. Please, do we have questions? The mentors have actually said a lot and they would have to be leaving soon. So if you have a question, please just ask your questions. I think that it's very important that we ask our questions, but I don't know if it's a Nigerian thing or if it's a learning thing. I don't really know where it's from, where people are shy to ask questions. I don't understand, because I know that even coming into this practice, it was not so easy for me. I had a lot of questions on my mind, and if I had this opportunity, I would have definitely asked the question. So for those of us that are students, by the time you come out, how do you want to even start in this space? And then for those who are already practicing, please ask your questions. They are all here because of you. And if you're not asking the question, then that means you know everything already. Or if you understand, just unmute and say, I understand. I don't need to ask the question. So
Juliana, let me add that the question doesn't have to necessarily be what we've presented. It might be what you're going through as a law student or as a practitioner, and we can always tie it back into, you know, the subject matter. So if you feel like you don't have a specific substantive question, that's okay as well.
Okay, so I will just call people and then you just tell me if you understand.
I have a question.
Okay.
So when we are trying to work with clients, and then at the beginning, at the initial stage, you tell them, okay, we have to register this particular idea, or you have to, you know, copyright this idea, and they refuse because of cost or something. And eventually they have issues with it, and then they come back, and then it's a whole different story entirely. In those type of situations, it's always difficult to go to the person that is using their idea. What would you advise to be done in that type of system? Because it's always causing issues.
I'll let Zerona go first, and then Oluwa Damilola, and then I can go later on. Go ahead, Zerona.
I think you're muted.
You're muted, Zerona.
Sorry. I had technical issue. Can you repeat the question, please?
I said that in situations whereby your client refuses to copyright their ideas, and then someone else uses their ideas, and then they come back to you, what advice would you tell me as a lawyer to do for them?
Okay. So they failed to register their copyright, or they failed to copyright.
Yes.
Okay. So one thing I actually wanted to point out was that copyright is one of the IP subsets. Copyright is one of the basically the law wants to protect. They want to give you copyright, so it's actually automatic as long as the work in question is original and that has been fixed. That is, like I said, written down or recorded, whatever it is, in a tangible form, in a way that's capable of being perceived, then the copyright is automatic. You don't actually have to do anything further. However, it is a good idea to register it with the Nigerian Copyright Commission, because that at least will give you prima facie, like it gives the public prima facie notice that this work is a copyrighted work, and like someone owns it. And it allows you to also have a date, even if it wasn't the date that it was created. You can say, well, here's proof that I created it prior to this date, and here's further proof that I had actually registered it on this date. And so if you're coming and trying to claim that you have ownership in this work, and the only ownership you can stay is after that particular date, then you've lost essentially. So first thing, if the client has not registered the work, first check and make sure that they actually they have copyright. And for them to prove that they have copyright, is the work original and was it fixed? If it was original, great. Next thing, was it fixed? Where was it fixed? Was it fixed in a place where, for instance, on your phone, if you do like a recording on your phone, there'll be a date on it. If you write something down, maybe you're writing down lyrics. Usually, depending on what technology you use, but most times when you're using like notes or whatever it is, it will have a date on it. So you can use that as evidence of when that copyright was created, and first of all, was it actually written down or recorded in that way? Two, that's great, and then check the date, and you can use that to prove your client's case. Am I still here?
Yeah, Oluwa Damilola, did you have something to add before I add something to? You are muted.
Okay, so I think Serena has said it, most of the things I have in mind. If in a situation where someone fails to register their copyright, it's I don't think it's a sin, so to say. It's just, like you said in your presentation, that it gives others advantage of stealing their job, which every writer or every person in business wouldn't want to happen to them, because you can't be working for someone and you can't be working for somebody to just be stealing your work. So basically it's just advisable to register your copyright when need be.
Yeah, and I would add to that, the only thing I would add to that is, Opolua, you mentioned that if you have a client who has an idea, and then it turns out that the idea has been, basically someone else has executed on that idea, what do you do? At least that was the initial fact pattern you mentioned. So if it's an idea, too bad, so sad. The law does not reward people who sit on their ideas per se. It has to be, as the owner said, that immediate threshold, and we've all said it too. It has to be fixed in very simple terms, in a concrete form. Original idea fixed in a concrete form, whether it's written, whether it's recorded, it just has to show you've done the work. The rationale behind that is the law, and as a whole, governments want to encourage creativity, want to encourage and push people to do work. So if you have an idea and your client comes with an idea but doesn't execute on it, again, too bad, so sad. However, notwithstanding that, that's just using the vehicle of copyright law. There's a different thing that client can use. So if that client still comes back and says, I have an idea and I'm going to meet, let's say, house of major fashion designer, or house of major or record label or whatever, or even a patent idea that they have, utility patent or design patent, and they come to you and they say, I have this idea, what do I do about it? Because I'm going to share it with a film company, etc. You just say, okay, well, you can have a contract drawn up on behalf of that client that says, if I share the story on the film side, for example, with you, and it turns out that you go filmmaker and make money off of it, you agree that me sharing the idea, you're going to give me something out of it. So even though I may not have written it, it's not in concrete form, and I don't get to go through the intellectual property law part, I can still go through contract law to negotiate a deal where I get paid for giving you my idea for you to go build it out. So, you can advise your client accordingly in that format or that form to consider that.
Thank you very much. Do we have any more questions, or do we all understand?
I have a question. Okay, can I go ahead?
Yes, you may go ahead.
Okay, my question is an unauthorized use of a trademark in the film industry, particularly if the trademarked goods are portrayed in a negative light. What legal action can a person take? That's the question.
I have a question too.
Unmute, Juliana.
You can quickly ask your question so that they can take the answers together.
Good evening, everybody. Okay, the session, it was really an enlightening one. With fashion and law, and I think something about it. We found things, infringement of trademarks. Like Nigeria, this rampant.
Let's
So
say
that
I
sometimes
can't hear you clearly.
okay.
Yes.
So can you hear me now?
Yes, I can hear you now.
By research, we're able to see things such as infringement of trademark with the fashion. And we know that in Nigeria, as the Standard Organization of Nigeria.
Okay, I think it is breaking. Like when you're speaking, it's. Or am I the only one that's?
Yeah, you can probably write it in the comment
Just,
section.
yes. Just please write it in the chat section, and I'll read it out for you. You have any other questions? Okay, so
Answer to the first question, please. So that's for film. So maybe Zerina can take it.
Yeah, Zerona, please feel free to lead. I'll come behind you on the film question.
When a trademark is used negatively in a film.
Okay. The question was, sorry, Julia.
Is used negatively in a film.
Okay. So, like Ms. Udwak said, trademarks essentially indicate ownership, quality. You know, they basically it's the bedrock of your brand, right? You don't want your trademark to be watered down. You don't want it to be abused because it does form, a great deal of value towards your brand, and so that's why there are laws against what's that thing called? The word just escaped my mind. I'm so sorry. But essentially when people come and they make counterfeit.
Counterfeit goods, yeah.
I said yes, but in a situation like this where a film producer has gone and, used, like we said, Coca-Cola, they didn't get the permission from Coca-Cola. Maybe in the film someone drank it and they got ill and they, I'm just leave it there. So they drank it and they got ill. It's a big deal. It's a really big deal, especially, because films are very powerful. So if they shot that scene, acted the scene really, really well, it could be a really bad look for Coca-Cola. The question is that when you have vision, so to speak, of the owner of that trademark, or at the very least that you're in some way associated with them, and so they don't want that. Essentially, bottom line is, to answer your question, where you use a company or an individual's trademark without their permission, because it is an exclusive right? When you use that without their permission, it's known as trademark infringement, and they can sue you for a lot of money. And if your film did very well, they can take the whole thing. If that producer's film did really well, they can take the whole thing. So depending on what side you are on in that particular argument, make sure that as much as possible, if you're on the side of the producer, try and see what indications you can to water down the damage that potentially may have been done. Prepare arguments in that regard. You'll also want to find any sort of indication, whether maybe you had a conversation with Coca-Cola, and they had given some sort of tacit agreement for you to use their brand. Make sure that you have some sort of documentation in one way or another. It may not be strong, but you will want to have something to back your argument, to back your client up. If you're on the side of a brand like Coca-Cola, then it's very clear to see, listen, we didn't sign any agreement with you that gave you this permission. We did not receive any money or give you any money for you to use our product in your film. Any sort of indications that would allow, that would, basically bolster your argument.
Yeah, I was trying to pull up a case that I remembered that got global recognition, Little Nas X. I don't know if everyone remembers that case. The Little Nas X is a hip hop artist here in the States, controversial, very controversial. And so he went and used Nike shoes, and from what I can recall, there was some sort of painting of blood or something, and then tagging it as Satan, like a shoe with blood and all that, and tagging the Nike logo was on it. It was a Nike pair of shoe, and tagging it on the Satan shoes kind of stuff. Anyway, Nike was not happy about that. So what Nike ended up doing was filing a suit saying, you will stop, cease and desist. And let's just say that was resolved in favor of Nike without it having to go any further than it needed to. In the context of filmmaking and a movie, the first thing that's going to happen if you're advising your client is you want to make sure they have those clearance rights. And the nice thing is, depending on the film depending on the product they're trying to use. So if it's trademark of Coca-Cola, using Zorana's example, for example, and you go to Coca-Cola and you explain what the story is, what it's, the script, they see the log lines, etc., and they see the pitch deck of the film, then they can say, you know what, we want to support you. And because we want to support you, depending on the deal, they might even give you cash funding for that film, among other things, and give you those clearance rights with no issues on it. So it's always a good idea to work with the brand because it's more beneficial. Now, if you're in the scenario you talked about where you in fact, and just backing up a little bit, if you're at the onset of it, trying to go to Coca-Cola to negotiate those deals, they're going to spell out word for word how you're supposed to present their brand, including that you cannot present it in a negative light. So that's generally how that would work. Assuming you didn't do any of that and you did it the Little Nas X way, then Little Nas then that result will be similar to what Zorana is already talking about, which is that most likely you will encounter a lawsuit that's going to force you to absolutely take that down. And the lawsuit will be more so filing what's called an injunction. So an injunction is basically making you stop it, take it off the market anywhere and everywhere it's been distributed. And that can be very, very, very a major blow to not only revenue, but your brand as a whole. You'll be lucky if you can recuperate from it, especially if you're going against a big brand. So it's a good idea to always get those clearances so that you don't have to deal with such issues down the line.
All right. Thank you for that. And our final question, given the prevalence of counterfeiting, knockoffs, and trademark infringement in the Nigerian market, what are these big brands doing about it? Are actions being instituted? Are there talks with relevant stakeholders in Nigeria to curb this menace?
Yeah, I know I mentioned that on the fashion end, and I think it appears that's what you're talking about. as well. And then when you say brands, I'm just looking at your question, when you say brands, presumably you're talking about American brands, because Nigerian brands, we're not seeing the same counterfeiting issue here. So with respect to American brands, there are lots of very proactive steps being taken for counterfeiting goods. Certainly, I've had matters where I know for sure Border Patrol gets involved in that. Law enforcement gets involved in that. The hypothetical I was given in my presentation, where there's training to also inform staff, to inform employees, to inform everybody across that entire business value chain that knows what the product looks like and when a trademark infringement is happening. On the Nigerian end, really, it takes the government stepping in to help out for those law enforcement, confiscating products, etc. So far, so good. You've not really seen Western companies really push on a lot of infringement that happens on the continent and in the Nigerian market. So far, so good. I think a big part of it is looking at the cost benefit analysis of it all. And to the degree you see them doing it, it's when the products are coming here. And for the most part, you don't necessarily deal with that kind of situation. Where you do deal with that situation is if you're talking about our movies being pirated here, our Nollywood movies being pirated here. If you go back to the Nollywood movies on both ends, there are two forms of counterfeiting goods that we see. One of which is involves both the trademark and copyright infringement. We scream a lot about how our works are being pirated, but we've been ringleader from day one with our Nollywood movies of music that does not belong to us, especially old Nollywood. It's everybody else's music but our own. And we certainly need clearance rights for those things as well. And then on the trademark side, you're seeing locally law enforcement over going to the markets, confiscating products, et cetera, et cetera. But it is something that the government has to be actively involved in on US products or Western products, or even Chinese goods coming into the market. And a lot of those Chinese goods are also fake goods. And if they don't get involved, it's really, really, really hard for the creative who puts a lot of energy and work into that manufacturing process, but has no real return on investment. So that's the challenge, and there's no real answer. On the US side, they've done the cost benefit analysis, and for right now, it doesn't appear to make sense monetarily to pursue that. On the Nigerian end, there needs to be more stepping up by the government to be involved in helping both on the international and local front. So that's how I would answer that.
All right, thank you, Ms. Uduak.
If I could add to that, just a little bit. We've had like a few clients actually, like Japanese clients, for instance, or Chinese clients who do create, especially technology, things like that. And so, they have reached out and they do pursue action against it. We work with a lot of the Nigerian agencies. They are trying, but you know how Nigeria is, so it's a matter of, it can be slow at times. So definitely there are those infringement actions that are brought against some of these major companies actually that are doing these counterfeiting. And then also there was a major fashion house that created here in Nigeria that created a very distinctive fabric, and they were using it to make these beautiful outfits that were like a statement piece. And what happened was that people started to copy the outfits and the fabric, and so they did pay a lot of attention to us protecting it and going after those. Maybe they might be small, but by the time the people who are doing the infringement, they may be small companies or a small tailor who works from her house or whatnot. But essentially, protection is protection, and if you own something, you own something. So you have to sometimes go after the little guy or the little woman to make a point to make that happen. So definitely, our designers, our creatives over here are taking these rights very, very seriously and doing what they can when they can to ensure that their rights are protected.
And I will add that one of the reasons you want to ensure that you follow through before you would say, now the person is just tailor trying to just make it, what is your own? But the reason why you now want to push is a little bit on that. Hopefully you don't appear too overbearing, because that can affect publicity and people buying from you, etc. But nonetheless, the reason why you want to push is we're in a digital age. That image is taken of maybe that person wearing, the infringed upon fabric design of a local tailor that is making that clothing, and they put it on social media, and now everybody's buying that pattern, replicating it and wearing it. And so you, the original creator, don't get any benefit from it, and the work is completely infringed upon. So I absolutely agree that it's important. I mean, strategize obviously, but it's important to also look at ensuring that you try to enforce this rights. And if you're not enforcing them on the trademark side, then you have a problem of dilution of your brand, because you're not enforcing it. And that can ultimately, when you come back to say, oh, let me enforce it, might not have some bite or teeth in it as well.
All right, thank you so much to our mentors. Thank you so much to all our mentees that are in attendance. In the absence of any other questions or answers, we'll let the meeting come to an end. Thank you so much, everyone.
For a beautiful anchoring. Thank you, Oluwadamilola. Thank you, Ms. Uduak. Thank you, Zerona. Thank you so much for coming. Thank you for sharing. Thank you for pointing out your knowledge and on us. We're so grateful. Thank you to every other person, Mr. Max, Mr. Polarin, Mr. Adetula, Mr. Wesi, and every other person that is here, to the mentees to encourage us to try to read on this topic. And it's important that we ask questions. Questions cannot be too much, and if you ask, you know better. Thank you so much, and have a lovely day.
Thank you so much for having me. Zorona, it's always good to see you, and Oluwadamilola, good to meet you. Take care, everybody.
Thank you.
Cheers.
Thank you.
Bye.
Take care. Thanks for having me.
Bye.
Bye.